Hey, what's up, everyone? Thank you so much for tuning in to another episode of the Financial Griot, aka TFG. Here, we love to just share our stories and introspection of just what's going on in our lives, but more or less to share our wealth building journey with you all. And hopefully, you can take those stories and create into actionable steps. I'm one of three of the co-hosts, Alainta Elson, and today I am solo. Technically, I'm not solo, but I'm solo in terms of co-host. Yeah, I'm all alone, but I have a very special guest with me today. I have Miss Jen Gumbel that we met at FinCon. And we just, let me tell you, FinCon just been one of those wonderful highlights of my year of 2022, I think. And it's just like meeting you, meeting other collaborators, financial literacy content creators. And it just been just a wonderful like journey so far. Within the last few months, like the highlight of my year just like, shot up. So Jen is actually an estate and probate lawyer. And we had a great discussion at FinCon. I think, if I'm not mistaken, Jen, one of our discussion was about the differences between wills and estates and trusts. And you were explaining to me where, is actually all these components are different. And it's the driving component of what to actually do in the event that, you may pass away or your family member, or you're incapable to make these decisions, like sick or medical issues, whatnot. So I thought Jen will be such a great asset for our podcast because we speak a lot on TFG about estate planning, about retirement, right? Lawrence, one of our other co-hosts, he always says that, if your if your parents do not have a retirement plan, just know that you are their retirement plan, right? And I think of it in retrospect in terms of, after death, how does that look like? Do you have a plan? Do you have a will? Do you know what your parents' wishes are? And more or less, and importantly, do you know what your wishes are and your desires in the event that you may pass away untimely? And I'm really looking forward to this discussion because it's very valuable. And meeting you, I know it was destined. It was destiny. You are awesome. Thank you. Yes, you're awesome. And I follow you on IG and I just love the content that you create and just putting more information out there and making it, I think, what I have seen so far and what I'm digesting with your information is it's making it more approachable to have these conversations, when you were talking about estates and wills, like I didn't know, I knew somewhat of a difference, but not really. And I just feel as though it's like, like getting into your content and reading more information. I'm like, okay, this is palatable. I can digest this, the complexity.
That's exactly it. Yes. And so that's really what I've learned. I do probate and I do estate planning, meaning that I deal with the legal issues that come up when people are incapacitated and when they die. That's what we term as like a probate lawyer, which in a lot of cases can involve an actual probate. But the estate planning piece is just planning ahead of time and doing what you can now to make those things easier. And what I've found over the years is, some people will leave a manageable to-do list and some people will leave a mess. And even people with great documents leave a mess because they didn't understand how it worked. And there's kind of this big gap between like vaguely understanding, yes, I need to get a bunch of legal documents in place, and actually getting, leaving a manageable to-do list. And it's a knowledge gap. And that's why I do my website and my podcast and Instagram and workshops to really bridge that gap so people can say, okay, now I know what this means and what I need to do. And then they can go about doing that in the right way.
Absolutely. That's a great point. It's a disconnection because of the knowledge that we just don't know. And it does cost us in terms of not knowing the information or the driving factor of what to do in the event, or if you're incapacitated or, untimely death of a family member or whatnot. I will ask just to back it up, because I know we can jump in.
Yeah.
That's just been your energy, just great energy and chemistry around you. This is jump in, but just to back it up, how long have you been an estate and probate lawyer?
Yeah, I've been an estate planning and probate attorney for just over 15 years in the state of Minnesota. That's where I practice. I'm technically inactively licensed in Florida, which means I am dangerous in that state, but it's really fun to kind of see how different states can be about that. And that's part of, I think, the difficulty in approaching this topic is it can be so vastly different in different states. So to kind of figure out what's going on, how does this work? It can feel difficult, but it doesn't have to be.
Right. It doesn't have to be. And again, it is a little complex. Can you explain what is the difference? And we talked about this, and I have a great idea now understanding the differences. But can you explain to our listeners what is the difference between a trust, a will? I think, a trust and a will, because I think people think it's one of the same, and it's not.
Yeah. So trusts do different jobs. Wills and trusts do different jobs. And, these are both legal documents typically. Wills have to be a particular legal document, meaning particular hoops of the state you're in. Trusts usually are written down. They should be written down. You don't want to be in a situation where we call them legally constructive trust, where you're acting like it's a trust, but there's nothing written down. But these are legal documents that do particular jobs. And in some cases, in order for you to leave a manageable to-do list, you might need both. But not everyone does. So here's what they are. A will is simply a communication to the court. It says where you want your stuck assets to go, who you trust to get those things there. And then if you have kids, that's the place where you say who you trust to care for your kids. But it's a communication to the court. So a lot of times I'll run into people who will say, hey, we won't have a probate because I did a will, or shoot, they never did a will and now we have a probate. And actually the will is for probate. It says what to do. It tells the court what you want. And it's important for everybody, even if even if you're planning to not have that process, that's your opportunity to talk to the court. So you still want to do it. A trust is a little bit different. It can be a companion depending on your strategy. And a trust is just a set of rules about owning something. So, for example, a rule that every trust is going to have is it's going to create kind of a function of a manager of assets and a function of beneficiaries of assets. They don't have to be different people, but they're different functions. And so, in my case, I have 4 little kids. And so if my husband and I die, then a trust is it's a component of our estate plan, because if our little kids, if we die and our kids are still little, then we need an adult to manage those assets for the benefit of those 4 kids.
Gotcha. So is it a fair assessment to say that just going by with your explanation, is it fair to say that a will is not only a communication to the courts, but it's also a delegation, that you are entrusting this person, that person to do what you need to do in terms of your desires or your wishes?
Yes.
Okay.
Yeah. So there's 2 things about a will. Number one, if you don't have a will, then the state fills in the blanks. So if you don't communicate to the court, hey, this is the person I trust, the court's going to say, all right, next of kin, depending on how the state defines that. And so if you don't communicate who you trust, then the court's left to just guess. And then they say the fallback of what the state presumes for everybody. And then the other piece of it is it's a delegation of a particular thing. So when it comes to transferring assets, some assets are going to tell us where they go through things like a beneficiary designation. Like if you think about a life insurance policy.
Oh, or like a retirement account too.
Yes, or an IRA.
Yeah, exactly.
Yes, exactly. So if there's a beneficiary listed, then that's going to go to that beneficiary. And so a lot of times people think, well, a will is going to say what happens to everything I own. It's kind of this global document of my wishes of what to happen. Yeah, that's great. But it's that communication to the court. And when it comes to assets, it's only talking about assets that are stuck. Does not affect the assets that have beneficiary designations, have joint ownership, or are somehow transferring automatically. And a lot of times, like, especially when I work with people who are single, who are charitably minded, they think, great, I'm going to throw like all of these instructions in my will. And I'm like, that's not going to work, because you like, where's your wealth? Oh, your IRA. Who's the beneficiary on that? My mom. Okay, that's great. But your charitable intent doesn't come into play at all, you know? And so really thinking of the strategy and how do we apply these documents correctly to the assets you have is a really, really big thing into leaving a manageable to-do list that actually is doing what you want.
Exactly. Okay. Now is coming all together
yes!
for me. So the will is the assets that cannot move. Like it needs to be delegated, it needs to be communicated that cannot move. Can you give an example? Would it be something like a car? Or,
yes.
Okay. Gotcha.
Yep.
Okay.
Cars are like standard. Usually, like, my state of Minnesota is really funny because we're known to be bad for taxes. We're really good at having different, like, lots of different ways to avoid probate. We can put beneficiary designations on houses, essentially. Like, it's not called that, but that's essentially what it is. We can put beneficiary designations on cars, I think, and boats. And I think it's just because we have so many lakes and boats and things.
Right.
But most people don't do that. They just have their car in their name. And so when they die, there's usually no designation on that. And that's where a will would come in. Now, whether or not you need a probate, in every state, it depends on how much is stuck. And every state's rules are a little bit different. And if what's stuck is under that amount, then you can go and collect those assets in a much easier way. Theoretically, you're still following the will, but you don't have to go through the court process to be able to have the authority to do that. So that's how kind of the what it really means to avoid probate is what assets are stuck in your name.
I don't know, Jen, you kind of explain probate as like something you just don't want to do. I'm like, probate is not sounding positive right now.
Right.
If you don't have the wills or the trust.
Yes. So probate, I get a lot of people who come to me in my legal practice, or, you know, as I'm sharing this information online, and they're like, how do I avoid probate? And you see kind of advice all over the map. Like, you know, financial celebrities, one will say, you need to have a living trust to avoid probate. And another one will say, it's not that big of a deal. Most people shouldn't have trust. And honestly, it's really a function of where, you know, what state they're in and what their probates look like. But the basic idea is probates are this court process. It's very methodical. It's very bureaucratic. And that's for a reason, because it's making sure assets are going to the right people, making sure that creditors are correctly addressed, whether they should be paid or shouldn't be. And it's getting the right person with authority, whether that's in a will, you've said who that person should be, or you don't have a will. And so the court is just following the rules of statute to say who that should be. And so it's methodical. For most people, they don't need that methodical process. For example, you know, I'm married, have 4 kids, you know, kind of the Cleavers were not a blended family. And so for our plan, it's a no-brainer that I want my assets to go to my spouse as easily as possible. My spouse wants his assets to get to me as easily as possible. And so there's nothing that a probate would bring to the table. I call it a stupid probate, where it's, you know, if, for example, in Minnesota, and I think most states are like this, if we have real estate that just has one person's name on it, or we don't own it together with survivorship rights, then that asset has to go through a probate process. So if my husband died, I would have to open a court process simply to get that asset into my name. Now, we both have wills, and it says, yes, I trust my spouse to do this. I want it all to go to my spouse. So it would go where it's supposed to go, but I'd have to go through a court process to do that, when I could have easily avoided that by knowing, how do we own our stuff? And is it moving automatically? Because that's our plan. And so that would be a stupid probate. In some situations, probate's really helpful, because if you have adult children who do not get along whatsoever, don't trust each other, you know, that methodical process could be helpful. But you could also avoid that through a trust process. That would, you know, and having trust and rules and saying, here's who's going to manage the asset, sell the assets, write checks to these kids who do not get along. And then you're just comparing the cost of setting up a trust, making sure that you're following through and getting the assets to say that they're following those rules, versus what a probate looks like in your state. And that can vary widely.
Yeah, that could vary widely, depends on the state. How does that work when, let's say you have set up in an estate planning or a will or trust, but this is prior to, let's say, getting married, right? If that estate or anything is not up to date, how does that driving force, get that information to transfer? I know that could be a difficulty if in the event the spouse passed away, then where I guess a probate would come in to delegate of the asset of the home of the deceased spouse. Okay.
So it depends on your documents and it depends on what your assets say. So for example, when you go work with an attorney, we're always thinking like, okay, what if? Okay, what if? We're thinking of all these reasonably, likely or reasonably possible what ifs. So if I'm drafting a will for spouses, and I'm drafting wills for them, then I'm always saying, what if? What if one of you dies and the other one doesn't update their will? Do we know what the plan still should be?
Right.
And if they say, well, then my kids would be the personal representatives and my kids would get the assets, we draft that in there. And so a lot of times, if I meet with someone who's just lost their spouse and we say, okay, let's take a look at your documents and see if this is still working within the strategy. And some documents will. Some documents might have to be updated. But that's a really important time to reevaluate and see if your strategy needs to be tweaked a little bit. There can be rules in place. So there's some rules that try to protect spouses in those situations. Like my state has a rule that if you get married and you haven't updated your will, there's some protections for that spouse. But the problem is, that's the protections that the state has. It's not what necessarily exactly how you wanted it. And that's also means when you rely on the state to fix something, that means you go through the court, and that's messy. So it's a really important time to just double check your strategy, update your strategy, see if the documents still work, if they need to be updated. And then the final component of every effective estate plan, making sure those assets follow whatever your plan is.
Okay. Yes. I could definitely see that, because what it sounds so is like, if you don't have updated draft, updated communication, the default of that will fall to the court. And depends specifically on your state. You don't want to be defaulted on the courts, because they will just place the information or asset based on the state law. And you don't know if that may be a good thing for you or a bad thing for you. Okay. You don't want to leave it there.
Yeah. It might do exactly what you want, or it might do something completely off the rails.
Absolutely. And I think when it comes to just young people, millennial, Gen Z, whatnot, is already I think less than 50% or a little bit under 50% even place, on contribution or match their contribution for retirement. So they don't see, I guess it's just like a narrow lens. They don't see anything else outside of being young and being, mobile and doing all these things. So retirement is so far-fetched for them. It's either their lens on. So don't think about an event they could pass away. Don't think about incapacitated. Do you have, or in the past or even now, have clients who are single or don't have children right now? Yeah. What is the estate planning, or what do you try to encourage them to do?
Yeah, so I say that every adult needs an estate plan. It just looks different at different stages. If nothing else, you have your autonomy. So you think about like Britney Spears, she had a lot of money. So there was a lot of incentive for other people to come in and get involved. But you don't know, as you're beginning to grow your wealth, are you creating an incentive for people around you to get their fingers into things? Or just the emotional relationships that you have where let's say you have divorced parents, and if you haven't said, this is the one who really, should deal with my decision making, if I can't do my own decision making, then you might be setting up a really difficult question for a court and potentially a mess and a disaster. So the first thing you should be thinking about is, I have my autonomy. That's important. What should I do? What makes the most sense? So that if I lose my ability to do things for myself, that the best person is in place to do that. So that's step one in the thinking. And getting those documents in place and thinking through that strategy is fairly low cost. It's a few $100s when working through an attorney who can talk you through all these things and the ramifications of naming people now and all sorts of things. That's fairly low cost. And then as you gather assets, you just have to think of a simple question. What happens with this when I die? And so you start your first job, you have a checking account. Okay, what happens with this when I die? And it might be as simple as a simple designation at the bank, where you're saying this person gets my bank account. And then as you progress and you say, okay, maybe it's time for me to get a will because I have too much here where it's going to be, I really need to set my own rules and not rely on the state. And then once you start, you get a will, then you're starting to meet with an attorney, talk about the strategy, what should be, what makes sense, what doesn't. And then when you understand what a will does and you understand what a trust does and why, like avoiding probate, you start to know the questions to ask and you are able to evaluate what someone's telling you so you can get an effective plan.
Right. Yeah, this is great information. I wonder, do you come across clients or potential clients that may not have an estate, right? They may have, an IRA or retirement account or a bank account, a basic banking account. What are some practical, I guess, information or things that they may need to consider for the future if they want, or maybe just having a documentation in place?
Mm-hmm. Well, one thing I encourage everyone to do, and this is something that you don't need to work with an attorney to do. It's like the first step. Understand what you own and understand if there's beneficiary designations on it. And when you start to do that, you're starting to your gears are starting to work in the right way to leave a manageable to-do list. So then down the road, when you do meet with an attorney, then you can start to say, okay, now that I know this particular strategy, then do I need to update my beneficiary designations or, how do I get my assets to now meet the new plan? So what I would encourage everyone to do, and I can give a link to a document that can help you start to think this way, is understand what you own, gather information about what you own, and then double check what beneficiary designations are on there. I'll give an example from my own life is that when I was in high school, my mom got a life insurance policy for me because I could qualify for a scholarship with the company. Okay. Really awesome. I got low cost, the insurance locked in is super, super cheap insurance for me. It was a great situation. And the kind of no-brainer was, well, if I die when I'm 18, then my mom should get the funds from the life insurance policy. She was my beneficiary listed on my account. After I got married, then I had to think, okay, that designation is now wrong because now I would want it to go to my spouse. That's the kind of thing that you have to think through in order to leave a manageable to-do list, which is something everyone should want to do. You leave a mess for grieving people, it's going to be extraordinarily emotionally draining. And it's very easy to just, learn a little bit of how this works so that you can leave a manageable to-do list. People can see what page, can see how you wanted it to be, get on the same page, assets follow what they're supposed to. It's a night and day difference.
Right. And you mentioned about autonomy, and that's a good way to think about it because now we're young, fairly young. Well, let's say that we're fairly young.
Yeah.
Fairly young people, healthy. Young and healthy, right? We're mobile, we're healthy, and we have this autonomy to make these decisions and our desires and our wishes, right? So I wonder, when it comes to making these decisions, how does one kind of foresee if, let's say, in the event that they can't do anything? For example, if you are, not married, don't have children or anything along those lines, what'll be something to just say, oh, would a paper suffice or some form of document? Does that change? Because let's be honest, a lot of people. Yes. Okay. I'll say this. I don't want to play. I'll use a celebrity. I know. If I'm not mistaken, Aretha Franklin, right before she passed. Allegedly, it was said that she wrote down her will, her trust, her desires on a piece of paper, on a piece of napkin, if I'm not mistaken. Right. So how let's say hypothetically, how does that work? Either you're verbally communicating this to a family member, or you wrote it down, you didn't get it notarized, you didn't get anything. How does that actually work?
Yes. So the first thing is, verbal things, don't verbalize it if you don't get it in a legally effective document. I can't overstate the mess, the heartache, the bad planning that people do with their own finances because they believe something is going to happen and then it doesn't. In most situations, a verbal statement is not going to cut it. There can be some really goofy, there's always goofy exceptions to the rule, but very rarely is a verbal communication going to be the goofy exception to the rule. So don't verbalize unless you're willing to back it up with a legally effective document. Okay, so that's step one. Step two is, what's a legally effective document? Some states are really kind of free and loose about this, which usually the free and loose states create problems. So, yeah, and I can't remember what state Aretha died in, if it was California, if it was another one, but California is like the big one. They're free and loose. They're like, well, if you can do a will and have like witnesses, or if you do it fully in your own handwriting, that'll work. But then they have all sorts of different, they have, some of their courts have said, well, if it's a form, that's all in your handwriting. But, what does it mean if you typed it on a computer? Or, well, how much of it has to be in your hand? Right. And anytime courts are saying what if, what do we do? Then that allows for family members to say, well, if it goes this way, that benefits me. If it goes that way, it benefits you. And that's where people have court fights. My state is handwriting. What? No, no, you have to have two witnesses, period. If you notarize, it makes the process easier. I know our court system, if it's not also notarized, we have to go through a few more hoops. But if a will is witnessed by two people, it is valid. But I have seen people with DIY documents, or even documents they did with a lawyer but they didn't get their assets to follow the plan. Both of those situations still create messes. So I encourage people, DIY does not have a strategy. You don't know, you don't know if you should have a trust or not. You don't know, you're not asking the what if questions. What if my spouse dies? Oh, okay. Well, I need to say who then would do things. And that's the value of attorneys, to strategize all of that stuff with you, get really good legally effective documents. I've seen a lot of people do DIY and they didn't do the hoop they needed to do to make it effective. And I'm like, well, this is great. In my state, we don't care if it doesn't jump the hoops. We don't have the argument saying, well, we think this is what they would have wanted. It's no, if they wanted this to work, they needed to figure out how to make it work.
It makes it non-valid. So conversational, anything like that, it does not matter. It has to be documented.
Yeah. And the difficulty is states are all over the map. There's this whole range of oh, we're going to try and figure out what they actually wanted, and we're going to take all evidence. And some states are like mine, where they're like, we're not playing this game that incentivizes fights too much. You do it or you don't. And I like practicing in that state. It makes it very easy as an attorney to play in that state. But you just don't know. And you don't know what kind of state you're in. And you want to make sure whatever you set up actually happens. And, and that's, again, why and attorneys are invaluable. When you know how this stuff works, then you know how to be a kind of an educated consumer of those services.
Yeah, and you're able to guide the spouses or whomever, your client, to make sure that everything is being designated, communicated, delegated as much as possible for assets, things that do not have beneficiary information. Can you, cause you've been practicing over 15 years estate planning and probate. Can you give some common patterns that you see throughout the years, or if patterns at all have been changing or trends? Because we live in an age of social media. And a lot of, we call it on our podcast, microwavable information, where it's tidbits information, and people kind of take it and run with it. This is what I need to do. And where it's not, honestly, most time it's not copy and paste. right? It really depends on your life circumstances. Like you mentioned, where you are in your life and, you know, the assets that you have, if you don't have beneficiary information. So can you kind of, as you've been, you know, practicing, can you kind of give us like, what's some things you have been seeing? Good and bad.
Yeah, good and bad. One of the big thing goes back to the financial celebrities who say everyone needs a living trust to avoid probate. You must avoid probate. And another one will say, you know, most people don't need a trust. Don't worry about it. And I know why they're saying it, because I know what state they live in, and they don't know what they don't know. They just know what they have run into, you know. So some states like California, like there's a few states like California, Florida, my neighbor Iowa, where I'd be like, I don't want to probate there because their court fees are, you know, I think California, the court fees are a percentage of the estate. Iowa lets attorneys and personal representatives take a percentage of the estate. Florida, you have to have a personal representative located in Florida. So if you're a snowbird and hoping.
Right. Oh, yeah. 1 second, Jen. So you said that if an event, a probate has to be entered, or I guess has to occur in the estate planning or whatever to devise the assets, they will take a cut from those assets. Yeah, I had to come back. I'm like, what you talking about? They take a cut from those assets. Okay, gotcha.
Yes. So like California, if I understand it right, in California, I believe that the courts, their court fee to file the case is based on how big the estate is. And in Iowa, your personal representative is compensated by how big the estate is, regardless of how complicated it is. Small estates can be super complicated. Big estates can be super easy. In my state of Minnesota, the court, there's one filing fee for everybody. The Prince Rogers Nelson estate, the most complicated, most famous estate that we will ever have in the state of Minnesota, the filing fee was $350.
Oh, wow.
That's everyone's filing fee. In Minnesota, attorneys are compensated based on the work they did. And that's a hard and fast rule. And so we have to show our work. We have to say, like, this is what we did. This is our rate. Here's why we're being compensated, what we're being compensated. Same thing with personal representatives. But other states are like, nope, we're just going to make this easy and say you get 3% of the estate. And depending on what's going on, that can be a vast overpayment or a vast under, it's just, some states are messy and expensive and time consuming. Some states try not to be. And it's really a question of like, what do you need to do to avoid it? What would it look like if, you know, what does it look like if you're stuck in it? What do you need to do to avoid it? And like, what's the cost benefit and analysis between avoiding it and not? And again, that's why it's a strategy.
Right. So I guess too, when it comes to when you're trying to regurgitate this information or seeing things online and applying to your situation, the trends that I'm seeing as well, like you mentioned, like the living trust, you have to have a living trust, or you don't have to have a living trust, or you have to have, you know, all these documents. What do you say is like, okay, this is just wrong. Like, this is just wrong information as a estate planning and probate lawyer. Like, stop listening to this. We like to highlight wrong information.
Yeah. So, you know, again, it's the one size fits all, you know, recommendations. This really isn't. And there's really, I don't see any disruptor in the industry that replaces a knowledgeable attorney who says, this is what probate is like in our state. This is what, you know, like, let's look at your assets and see what we can do to avoid it. You know, what options do we have in our state? In my state, because we can put designations on houses with a particular type of deed, the vast majority of our clients are looking to avoid probate. It's not as bad as other states, but usually they're stupid probates. We can avoid them in other ways. And in our state, you know, maybe half of those people need the rules of a trust and half the people don't. We just have to get assets to move automatically to the right people. And so this is not a one size fits all. But the information that you need to know to be like an informed consumer, that's the crazy thing is like, and that's the thing that I see this gap where no one's talking about it, is the information that you need to know is not state specific, is not specific to particular individuals.
Right,
like you can become knowledgeable enough about this to say, I don't care if I'm living in Florida, California, Minnesota. I don't care if I'm married or single. I don't care if I have kids or not, or if I have a vast amount of wealth, or I'm just starting, to acquire assets. I know what an effective estate plan means, and I know how to ask the right questions. And that's where, all my stuff is coming from, is trying to give those people, give everyone that base of knowledge to be able to say, okay, I know what I need to do, and I know how to bring in a professional in the right way.
Yeah. So you're equipping them with the tools, but more or less just, the knowledge of what to ask, what to look for, and not just copy and pasting information, what you heard online, what you've seen online.
Yes. What your cousin did.
Right. What your cousin did, because it's more specific to your state and your assets and where you are in your wealth building journey. And however that looks, if you have children, if you don't have children. I was looking on your website, and I do see that you're offering like services and a workshop, if I'm not mistaken, as well. Can you just explain more about what the workshop's about and what you're trying to your purpose for it?
So the workshop is for individuals who are looking at this and saying, I do not want to leave a mess, and I want to I'm ready to learn what I need to know and take the steps I need to take to leave a manageable to-do list. And what's really fun now that I've I've been doing the workshop for a couple of years, the first thing is that it's like technology is awesome, where it's on an online platform where you do it on your own pace. So I have some students who are like, in a day, they watch all of the videos and they just inhale this information and then they go out and do. I have a lot of other people, and this is where I really saw it in my day-to-day practice, where I try to bring my clients up to speed, but they're signing documents. I get an hour with them to talk through this stuff. And it's still it's a lot at one time to wrap your head around. And so the ability to just take the information in and then sit with it for a little bit and be like, oh, that's what a trust does. Okay, let me sit with that for a little bit. Okay, now let's go to the next thing. The ability for people to do that it's just really cool to watch, because the feedback I get from students is like, oh, that's how it works. Oh my God, now I get it. I've had past clients who've been students who've said, now I understood why you did the documents you did, and we know when to come back to you. It's just so cool to see people who are empowered and not confused. So that's my workshop. I also started kind of a little like a boot camp, because I also get the feedback where a lot of people are like, Jen, I know I need to do this and I know I should do this. I'm just too freaked out about my parents to start to think about my own. And I'm like, well, that's part of helping your parents, is you doing your own, so that they know this is what adults do. It's not just for old. Yeah, it's not what old people do. It's what adults do.
Adults, right?
Right. But just to how the boot camp is a shorter course where you're just introduced to the topics, so that you're knowledgeable, talking to your parents to say, okay, if you're incapacitated, what does that mean? If you don't do planning, what are the alternatives? Or, some people, in a perfect scenario, you can have the conversation with your parents. Not every scenario is perfect. And so sometimes you're just sitting there saying, I can't talk to my parents about this. I try and get shut down. And I just don't even know that whether they have a plan. I just know that whatever they do, I'm going to be stuck cleaning it up. And just to be introduced. Yeah, it's super scary. And just to be introduced to the legal issues that come up, so you can say, okay, whatever they're going to leave me with, I at least know what's out there. And that's the purpose of the boot camp, which is a new offering that I've put out there when you're just too freaked out about your parents to think about anything else.
Right. And I'm happy you brought it up with the parents, because we do talk about, estate planning, retirement planning, helping your parents? How does retirement even look like for them, or if they get sick or untimely death, right? Have you ever had any experience where the child is involved trying to, I guess, ease the mind of the parents, or making them more aware or more knowledgeable of how estate planning or trust and wills work?
Yeah, I'd say a lot of people see attorneys for the first time because their kids say, you know, and I don't recommend this. I have a video talking about the things to do and not to do with your parents when you're talking about these topics. But a lot of kids will say, "Mom, Dad, you've had a health scare. Dad passed away," or, you know, we really can't put this off any longer. And they actually, you know, set up the appointments and all of that. And as attorneys, you know, from an ethical standpoint, we have to be really clear who our clients are. We have to be really clear that we're serving that parent kid. We appreciate you starting the process, making the call, but you don't get any decisions here. It's all with those parents, and they get to decide what they share with you. You know, but a lot of estate planning doesn't happen until kids, you know, start to be honest with their parents and say, "Look, I'm losing sleep because whatever you leave, I'm dealing with.
Right.
And absolutely. I need to know that you're doing what you can to make that not as difficult on me."
Oh yes, that's the driving factor, because even I'll say even like starting those conversations, but if you can actually lead your parents to a state and probate lawyer like yourself, an attorney to speak to, kind of ease their mind, or have those conversations of how you know, afterlife may look like in their assets and their desires and their wishes, then that's like major kudos. Because I think I can speak from my experience is that, you know, I'm the youngest of 6, and it took so long for my mom just to get life insurance, right? Because I think at some level or some point too, as you know, parent, just me thinking how she may think is that now she's looking at her mortality, and it's like, okay, I may not be here for my children, and it's not the fact that, you know, we're out to get you and we just want your things,
right? Yeah.
You know, I think back in their mind, my mom just can be that morbid sometimes, but I think also she had to come to realization that she is getting older, and it may come to a point she may not work, may come to a point that she cannot move or fend for herself, or whatever situation may be. You know, she don't want her children's stress under additionally, as well as grieving her death, you know, with all the other things that they have to deal with and such. So that's a great point, because you want to encourage or, you know, inspire and try to get them as much information, but they have to lead to get to the attorney, to get to everything else. And like you mentioned, you are serving the parents. If the child is there, great, thank you for your contribution. But we are for client privilege, we are serving the parents. That's a great point. And I wonder when it comes to like with aging parents and you know, like older clients that you may have, what is like, if you can give me any insight, what is like the worst case scenario? If you have any experience with that.
Anytime, you know, we are usually able to deal with complicated situations, complicated questions, complicated families. The time when it gets difficult, and it really isn't difficult from our standpoint, it's a difficulty for the family, is when we are past the point of them being able to make planning. When they no longer have capacity. And there have been situations where, you know, someone is diagnosed with dementia, and you know, there's a lot of people with dementia who still have legal capacity, and that's what attorneys are trained to do. We know, like, we're looking to see, do you meet the qualifications? How do we make sure that's, you know, documented in the right way? You know, that kind of stuff. So someone with the diagnosis that, you know, does this affect their capacity or not? That's not difficult. What is difficult is when we get the call of, you know, someone's in hospice, someone's been diagnosed. Okay, can I talk to them? No. What can we do? And there is nothing at that point. You just dealt the hand that is there at that point. You can't change the hand anymore. And that's the difficult times. And then we just say, okay, well, when the time comes, come in and see us and we'll figure out what we're dealing with and work from there.
Okay. Definitely. I see where you're coming from. And that is difficult. And that's so on a low point where you're trying to not only potentially grieve and help your parents, but you're trying to figure out all this estate planning, probate, however it works. So that is the worst case. I didn't even think of that. Is you're beyond planning at this point because the client can't even, communicate and delegate in anything. So that makes it really difficult to do. Have you been in if you can talk on your experience when it comes to children, because you mentioned about trust early on, and trust is, like you mentioned, is when you have minors, and in the event the parent passed away and they leave a trust, they can't, I can't give you all my money because you're only 8 years old, right? So I can't do that. Has there been any, like, I guess the documentation, if it's not really clear, you designate someone to be over, is it a trustee, if I'm not mistaken?
Yep.
Okay, a trustee.
Yep, exactly.
Is a trustee. What in a worst case scenario, what if the document is not as clear? Let's say if the document expires by the time they're 21 or however it happens, I guess, where do you come in if that's not clear for trustee?
Yeah. So administering a trust, I still recommend, whether you're named as a personal representative and have to go through the court. And that means you got to dot every I, cross every T, fill out the right things and serve it. So you definitely should be working with an attorney in that case. You get a claim in. What do I do with it? Do I say no? Do I say yes? Yeah. If you say the wrong thing, you're liable. So yeah, let's evaluate this. That's the probate process. But even if you're not in the probate process, if you're in a situation where you're named as a trustee, let's say for your nieces and nephews, in like kind of an awful situation, right? Your sibling is gone, the other parent is gone, or maybe it wasn't kind of the Cleaver situation, and the other parent is around, but there is a reason that your sibling did planning and did not plan for that parent to be involved in the finances. When you're in that situation, it's still important to work with a lawyer because we can help interpret. We can say, yes, you're doing the right thing. No, like that's not the right thing. Don't do this. You can get the guidance to be on, to keep doing things on the right track. It's just a lot more abbreviated because we don't also have to make sure the court's happy. We're only concerned that you're doing the right thing and that you have the authority you need to do what you need to do. The quirky thing with trust, though, and this is when they get hard, is where the assets didn't say they were following the plan. So like an example that comes up like way too often is people will set up a trust specifically for the purpose to avoid probate for whatever reason. And they're even working with a really, really good attorney who's saying not only is it important that we have a good trust document, but we're checking your real estate and we're getting your real estate through a deed of some kind of deed to transfer either now or at your death, get this house to follow the rules of the trust. But then you don't really understand, and all the things that you were told when you were doing the signing, your eyes glazed over, your mind shut down, and it didn't connect with you that this is organization. And just like organizing a closet, I can set up a great system. If I'm throwing stuff in the closet, my closet's still messy. And so you didn't internalize that piece of it, this financial organization piece that, I have this great system. I also need to make sure my assets are following the plan. So a lot of times what happens, and it's an awful conversation from the attorney standpoint, is when we say, yep, there is a trust. Yep, there are some assets that are following the trust, and we'll walk you through that, and we don't need to deal with the court for that. But they moved, and their house is still stuck in their name, and in my state, we have to go through probate to get it into the trust. And they're like, but we had a trust. And I'm like, yes, but your trust is just the rules. Your assets have to say they're following the rules. And when they don't, and when they're stuck, that's what decides whether or not we have to go through the court process, not the fact that they signed a trust. So it's really important to understand this financial organizational component to get your assets to follow whatever plan you have.
Okay. Yeah. Okay. Now it's coming more and more clear to me. I really appreciate this conversation, Jen. It's definitely becoming clear to me. So when it comes to in the event if a probate needs to be involved, how long average? And I guess this is I probably answer my own question. Is it more specific on the state or how complex the state may be? How average? I guess it takes.
Okay. So like, I love this question. It's going to be all over the map, different, way different depending on the states, the assets involved and the people involved. But I get to use like my two favorite examples of the Prince Rogers Nelson estate, which was bananas because I'm actually wearing my Prince shirt today because anyway. So he had lawyers for lots of things. He owned lots of real estate that no one knew about because he had really great lawyers set that up. He did not do estate planning. None of it. Absolutely none. He had no will. He had no trust. He had no designation set up. Everything went through probate. And my theory is that I have this theory that there are two reasons why people don't do estate planning. One is that they're intimidated by lawyers. The other is that, and he was not, like clearly worked with lawyers all the time. The other reason is people don't want to acknowledge their mortality. And then, so they think I will do this later when I can acknowledge it. And that's my theory on what happened with Prince is that he refused to acknowledge it. And so, he dies in his 50s out of nowhere. And literally everything he owned, some schmuck lawyer in Southern Minnesota, I'm able to see exactly every single thing that he owned because that's part of the probate process. His probate just recently closed. And if I remember, I think it's been a 5-year process. That's one end of the spectrum of how bad it can get. On the other end of the spectrum, Walter Mondale died a couple of years ago. So his probate was open the same time the Prince was. And it's like our two most famous people died. Walter Mondale was a politician. He was vice president under Carter and then ran against Reagan in the 80s. Okay. He did planning. So he had a living trust. The vast majority of his assets transferred under a living trust, but there was enough that was stuck in his name. From what I can tell, and this is what's interesting, is I can't fully tell. Prince Estate, I can tell you exactly what was going on in his life because he did no planning. Walter Mondale did planning. And so even though he had enough assets that were stuck in his name that they had to go through a probate process to get those things unstuck and into his trust, the cool thing was that his probate was open for the minimum possible. And for me in Minnesota, when I can open and close a probate in the span of 6 months, I feel like we have hit as quickly as we can go. And that Mondale estate opened and closed in 6 months. The only people involved was the trustee of his trust, and that's it. And because of that, they didn't have to get into detail on on things like an inventory on a listing of assets. That wasn't disclosed. It was like personal property, in excess of $75,000. Okay, that tells me nothing, right? And so the difference between planning, even when there was a probate, was night and day. The minimum that I can do here in Minnesota is 6 months. The maximum that I've seen in the state of Minnesota is 5 years. And that was incredibly messy, incredibly public. I can see everything of what was going on. So that's kind of your two extremes.
Right. And in an example where you can, this is public information at this point, where you can see Prince assets and where is going to, or however they designate it. Wow. I didn't even think of that in terms of like public information. When you think of a probate, it's public information. You don't want to get them. I guess in your experience, is it just best? Your position or your purpose is not to get the probate or the courts involved less as possible, to not just jump into all the things that your family is dealing with and where your assets is going. That is the purpose, where you just want to make sure is more more or less just smooth selling. Everything can just drive in the driving factor of it.
Yep, that's the name of the game, is People think of estate planning as I did my will. You're like, I signed a will or I signed a trust. And I think of it as you are thinking through the legal to-do list you're leaving, and you're trying to make that as easy as possible. And that means you have a strategy of how your asset should move. You have the right documents in place that are legally effective to set up that strategy. And then your assets follow that strategy.
Gotcha. So lastly, if a person is coming to you and they have all these things set up, in the event they passed away, what is the actual process where you are their estate planning lawyer, probate lawyer? Do you come in the situation once it's notified to you that now they have passed away, and now you're designated the assets and information and just notifying whoever that needs to be notified?
Yeah. So after a death, there's kind of two different types of people that you can represent. Excuse me. You can represent the people who have authority to act, or at least have an argument to say that they should have authority. So that's next of kin, and there's no will, or there's a will and it says this is the person who should act. Or it's maybe someone else, but everyone else is saying, I don't want to act. Can you do that for me? And that's the kind of practice that I have. Is I work with the people who have jobs, and they might also be beneficiaries. I'm not there to help them get their stuff. I'm there to help them do their job. And then there are other people who are looking out for what they think they should get, purely in the beneficiary, situation. And sometimes they disagree with what the person who has the job is doing, or they disagree with the documents, or there's no, they have some claim against other people. I happily have a line in the sand where that's not the kind of attorney I am. I help people dot the I's and cross the T's. And other attorneys can go, be part of fights. I'm not part of fights. I'm part of doing. And so usually what happens is I get a call because someone passed away, and they say, okay, now what do we do? And then I say, okay, I need to get some information. What did the person have as far as you can tell? And a big, big problem is people aren't sure what they had. And it feels like it's like watching, like Hansel and Gretel trying to follow a breadcrumb trail. And some people left a really clear breadcrumb trail. They're like, oh, here's this binder of all of their finances. And oh, that's where they banked. And oh, I found 3 like life insurance policies and 3 like quarterly statements from different IRAs. Great. And then they call those places and they're told if there's beneficiary designations or not. But they're just kind of following the breadcrumb trail. Some people have an awful breadcrumb trail, and they're like, I can't, I'm like digging through this house, and sometimes I'll find a document. I'm looking at the mail, seeing what might be there, like they just don't really have any clear information. And that a lot of times can be the most difficult part. But we start with the call, we start to figure out, okay, who has authority? And are those people, is everyone on the same page of who that person should be, or does that person have some clear claim of authority? And then we go from there, and then just start the process based off of what's stuck. And that's a lot of time is the most difficult piece, is figuring out what's out there and figuring out what's stuck.
Yeah, it seemed like a lot.
Yeah.
when they don't have it very clear for you as an attorney of who should be communicated, what should be moved, what assets and trustees. So it could be a little bit all over the place if it's not clear and documentation is not designated to who needs to go to who. In your experience with, let's say the event of a spouse or a sibling, and they were the trustee maybe, or if they were if they were like power of attorney or anything like that, and they reach out to say like, hey, my sister, she left me power of attorney, but I don't know what her for her assets are. What do you advise them, or what kind of information do you give them? That do they call the job? They call the bank? How do you go about doing that?
Yeah. So the first thing that I do, especially because my state, I think a lot of states are like this, is if real estate's stuck in someone's name, we have to go through that probate process. And so a lot of times I'll meet with somebody and I'll say, okay, there's something here giving you authority, or you're next of kin or whatever. All right. So now, find out as much as you can find out about assets. And if they essentially say, oh, we need to see that you're the executor, we need to see that you're the personal representative, that's the only reason, like, we can't release this. This is in their name and it's stuck. Okay, great. Let me know that. I'm going to go check the real estate. That's the one kind of asset that is publicly available, that has like a central database that we can look at. And so I'm like, you guys try to find out as much as you can, whether it's a lot or very little, find out as much as you can. I'm going to go look at the real estate. And a lot of times that's what's going to guide me. So if I see that the real estate is stuck in someone's name, I'm like, all right, let's start the paperwork. And then as you learn other assets, as banks are more free to talk to you when you're appointed personal representative, we'll start down that process.
Gotcha. Okay. Now I see. And like you mentioned, if the breadcrumbs are very like distinctive and is very clear and the route is clear, then it make it easier for you as an estate planning probate lawyer to designate and to communicate and to notify what goes where. Yeah. So it's very clear and distinctive. Your services, I remember you were recalling in terms of your workshop, and people are being empowered with their tools and information of what to look for, what to ask in an attorney, so they can know what is the best, document or best case scenario for them in event of anything happening. In the workshops, has it been anything where people were still apprehensive about like what to do, or do you feel like they were more encouraged after the workshop with information?
Yeah, I think the feedback I get is like this positive, feeling of empowerment. What's really interesting is in this whole system of like online education that's kind of developing it seems like this is something that's been developing over maybe the past 10 years, is online education, where people can say, I will pay X amount of dollars and I'm going to learn this from an expert. Is kind of figuring out the completion rate. And what's really interesting is that I think normally they say the completion rate hovers at some really low amount, like 10% or something like that. And what's really fun to watch is like, estate planning is not the most approachable topic, but is to watch students. And I think my rate's something crazy, like 75% or something like that, where they're doing the information. What's also interesting is that there's homework steps of saying, okay, now you're going to call attorneys to vet who's going to be the person who's going to do a good job for you, right? And that's a different metric. And so I have some people who complete the course and they complete all the steps. I have some students who complete the course, but they don't quite get all those steps done. And so what's fascinating, and something that I want to delve into more is, like, what are the hurdles? Did you reach out and you still couldn't find somebody? Or was it just a cost issue of you found somebody, you just can't do the cost right now. And that's something that you have on your to-do list, you're saving up, whatever. So yeah, I'm really fascinated to find out, like, to see what's all, it's so fun to watch students and see their progression and their feedback. And then to see, what else, can there be to move people forward.
Right. And online education, just like YouTube and even tidbits of TikTok. TikTok, if I'm not mistaken, Gen Z are now using the platform more than Google. From what I have learned, everything else, learning from professionals like yourself, or just like everyday practical information. And I think it's super cool when you are able to kind of gain that knowledge, similar to your workshop, and you're giving them the power to, like, hey, you can reach out to these people and these attorneys, professional, based on your scenario, based on your where you are in your life, to try to encourage them, like, it's accessible to you. And I think sometimes for young people, or even older people, sometimes they may feel like a cost barrier. They may feel like, lack of knowledge, whatever situation may be, or like you mentioned, acknowledging your mortality. But it's all accessible. And I love the fact that it's online, because we're constantly on our phone. Yes. The information is there. Yeah. We're constantly on our phone. Just to, in the discussion, any last things you want to tell listeners or potential people who may be interested in estate planning or wills and trusts? What would you like to leave them with?
Well, number one thing is that Google's hard to learn this stuff on, because there's no context. You don't know what stuff matters to you or not. I run into so many clients who they come in and they're like, I looked at Google and here's what the tax, like, here's the tax exemption. I'm like, that's great. You don't have estate taxes, but
right.
You don't know what your beneficiary designation does, So, and that's, that's why I go on Instagram, and TikTok. That's why I have the website, why I have the workshops, is to provide that methodical of like, let's teach you how this stuff fits together. And I encourage everyone to do that. The thing that I want to leave everyone with is, understand what you own. And once you have the plan in place, make sure your assets follow the plan. That is the difference between leaving an effective estate plan where your assets are actually doing what your documents say they're supposed to do versus, having documents or not, but still leaving a mess.
Still leaving a mess. Like it's like halfway done.
Yes.
Yep. And sometimes I feel like a lot of people just say it just to say they done it, but the document doesn't do anything when you think about it. After this whole entire conversation, it really doesn't do anything.
Yes, as a probate attorney, people like bring in the wills and be like, we don't have a probate, or they bring in the trust and it's like, well, we still have to do a probate because the real estate doesn't say anything about the trust, or there was an old beneficiary designation that goes to your ex and we need to work through that. And now we have a little bit of a mess to walk through. I mean, so many situations where people thought they were fine and they didn't understand it well enough to know that what it took to be fine. And that's where people, that's where doing like the self-education, becoming a savvy consumer is really important.
Absolutely. Well, Jen, thank you so much for this
welcome.
conversation. This discussion was great. Like I learned a lot, and I've been looking to the side, just placing some notes for myself because it's something I think about a lot because I'm a new, well, I won't say new now. It's been 2 years now. I own a home and I'm single right now, but I have a will, I have a trust, but like you're saying, it only do so much that you want to do, because having an estate, I don't want to be in a position where in event I passed away and then my siblings or my mother, the estate is still in my name, what do they do?
Tool.
Right.
Now you got to get that house to follow.
Exactly. So now I'm thinking about that. It's because those documents are important. And I want the listeners to understand, have those documents is very important, but you do need that driving factor where to take those assets. Where is your money is going if it doesn't have a listed beneficiary? So it's only as important as you have the more important, driving factor that you need. So this has been a valuable discussion. I really hope that, if you are listening and you do own a estate, or if you do not own a estate, understand that the assets that you do own, like for example, if you have a vehicle, if you have any valuable assets that you want to leave to your parents, you want to leave to a friend, your nieces, whomever, then you need to start having these conversations, have a will, have a trust, potentially look into hiring an attorney such as Jen herself, and get yourself equipped with information and the tools that you need and the resources that you need in order for your family to grieve in a healthy way, but not in a stressful way.
Correct.
I don't want my family to be stressed. I really don't, because they're already, untimely passing. They're grieving me. So you want your family to be in a healthy space where if you can have the ability and autonomy to do it, do it. So this is actually inspiring me to like, let me get on it.
So glad.
This definitely inspired me. Before you leave, Jen, can you let everyone know where they can find you as well as your website?
Yes. Yep. So my website is organizedafterlife.com. You can find out about the workshop and the boot camp there. There's other blog posts and videos and things like that, some free resources as well. And then I'm on Instagram at Jen Gumbel. It's BEL, like Bryant Gumbel, but Jen Gumbel. And I'm on TikTok also at Jen Gumbel. You can find me there. And find all sorts of resources.
Awesome. Thank you again, Jen, so much for joining us. It was a pleasure meeting you at FinCon. Constantly, we're communicating on IG a lot. And thank you for your content. Thank you for serving people and serving them with information and knowledge, and to know that they have resources, they have people to clarify these information what they need, because this is very valuable. Thank you once again. And I hope if you are listening, if you are listening, make sure you share this episode with someone to get more clarification on what is wills, what is estate planning, and probate, in attempt to lessen probate if something that you do not want to do for your family. Make sure you have all these information, everything in place for yourself. Once again, thank you again for tuning in to another episode of the Financial Griot. My name is Alainta Elson. You can find me in the IG streets at Alainta_Elson. Thank you again for tuning in. TFG, we're out.
Thank you for listening to the Financial Griot podcast, powered by the Wealth Builders Collective.